Dear students, I have come with a new module, Discharge of Contract Part 3. So in this module, we will explain the remaining topics which we have not covered in Part 1 and Part 2. So this is about discharge of contracts. What are the methods of discharging a contract? So discharge by lapse of time. As per the Limitation Act 1963, for breach of contract, legal action should be taken within a specified time called the period of limitation. We know that if it's a check, the validity in India is 3 months. Earlier it was 6 months. 2-3 years back, RBI has changed the validity of check to 3 months. So if you're presenting a check after 3 months, it will become stale check. If you're getting check from somebody, it's your duty to present the check before 3 months. And if it's dishonored, you have to inform the drawer and you have to get a new check or you have to take the action. Similarly, somebody borrowed money from you. The Law of Limitation Act says that 3 years is the time period. So if you have to collect that money from that person, within 3 years you have to act. You cannot keep silent for 5-6 years. Then all of a sudden you can say that he has to give money. So that is not possible. So otherwise legal action will not be possible. Within the reasonable time, within the time allowed by the laws or the acts or rules in the country, you have to act. This will be different for different rules and regulations. So banking, 3 months for the check and 3 years for the regular debt. Now, discharge by operation of law. This is the next point, that is discharge by operation of law. See, sometimes parties are not able to discharge the contract due to certain circumstances. One is death of the promisor. See, in the case of death of the promisor, his personal skill and capabilities are required to complete the project. A singer, a musician, a dancer, a magician, anybody. Even if usually in the case of death of the promisor, the legal heirs will take the decision to continue with the project or not, or with the contract or not. Whereas if the personal skill and capacity of the promisor is required, it is not possible for the legal heirs to complete the contract if they are not equally competent. So their death of the promisor will discharge the contract. Now insolvency. Insolvency meaning a person is filing a petition in the court saying that his assets are not sufficient to repay the liabilities. So insolvency will come to an end of the contract, because then the court will decide an official receiver. Receiver will collect the list of assets and list of liabilities. On that basis, on the basis of the supervision of the court, they will discharge the contract or the liabilities. Then merger. Merger meaning you are getting superior rights, or you are entering into any other contract which is you are getting superior right. See, for example, a tenant is buying a house property, then he is becoming an owner. So the discharge, the regular rent he was paying, he can stop paying. That is discharge of contract, because now he has bought that apartment or bought that property, then he is the owner. He can stop paying the rent. Discharge of contract. Unauthorized material alteration. See, if somebody will change the name, amount, date, signature, anything that will make the document illegal, it will not be able to complete that contract. Legal consequences will be there. That is unauthorized material alteration. If material alteration is possible with the mutual consent of the parties, by the parties entered into contract, and they were countersigning by all the parties involved. So if it's unauthorized, it is discharge by operation of law. Rights and liabilities becoming vested in the same person. See, for example, A has to give 10,000 rupees to B. So that is A has to give 10,000 rupees to B. At the same time, C has to give 10,000 rupees to B. That meaning we can take B out of the contract, and that contract can be between A and C. So that is the rights and liabilities becoming vested in the same person. So A has to give 10,000 rupees to B. And then there is another contract between C and B for the same amount. So we can exclude B from the contract, and the contract can continue with A and C. So this is the rights and liabilities becoming vested in the same person. Now discharge by breach of contract. Breach of contract meaning the contract is not fulfilled. One party is not fulfilling, or both the parties are not fulfilling the terms and conditions of the contract. When one party to the contract does not fulfill his or her contractual obligations. See, for example, sale of a property. So on the date of the sale, the seller is not ready to part with the property. So that meaning seller has not completed his share of obligation. Buyer is ready with the payment, all the documents, everything, but seller is not ready. Discharge by breach of contract. Makes it impossible to perform the obligation under the contract. The property registration will not happen because seller is not ready to part with that. He is giving additional conditions or whatever the reason. So this is discharge by breach of contract. Now, types of breach of contract. There are two types. One is actual breach of contract and second is anticipatory breach of contract. Actual breach of contract and anticipatory breach of contract we have to study in detail, that I am going to explain now. Actual breach of contract. At the time fixed for performance of the contract, one party fails to perform his or her obligation under the contract. See, one example is a person supposed to join a university on a specific date. He is not joining on that date. That meaning his act is actual breach of contract. Contract signed by both the parties, by the educational institution and the employee, prospective employee. But employee is not turning on that day to join the organization. Actual breach of contract from the part of the employee. A contract to sell car on a specific date. That seller is not ready to sell the car on that specific date. So that is actual breach of contract. But the seller refuses to give the car to the buyer on the same day. So that is only one party fails to fulfill his obligations under the contract. Now, what is the legal effect of actual breach of contract? Legal effect of actual breach of contract and anticipatory breach of contract are different. So you have to see that what are the legal effects for actual breach of contract. The party not in default can treat the contract as discharged. So that meaning the educational institution, they are not in default. So they can treat the contract as discharged. Or the buyer can consider the contract sell. In the case of the sale of car, he can treat the contract as discharged. Sue the party at fault. The educational institution can sue the person who is supposed to join, or in the case of car, the buyer can sue the seller and claim damages for breach of contract, whatever the damages, because the educational institution would have appointed somebody else, or the car, the buyer, he might have approached somebody else to get the car. So this damages he can claim. Now, what is anticipatory breach of contract? It happens before the time fixed for performance. That meaning before the due date of the contract, this is happening. There are two ways. One is expressed by word spoken or written. That meaning the party is informing that it is not going to happen. I am not going to fulfill the contract. Second is implied by the conduct of one of the parties. It is understood from the behavior of one of the parties. See, for example, expressly by word spoken or written. See, that meaning he is informing that I am not going to complete the contract. See, for example, if it's publishing a book, so on the date, I am telling that matter is not ready, I am not going to do that before the due date. Before the due date, I am informing the publisher, matter is not ready, I am not going to complete that project. I may need some more time. Anticipatory breach of contract. Or impliedly by the conduct of the parties. That meaning I have agreed with the publisher, but I am not happy with the royalty. So what I will do? I will not do the work. So I am not giving an indication. In the first case, I will be indicating that I will be doing. First chapter is completed. Second chapter is completed. I will be sending the proof and all. In the second case, I'm keeping quiet about that. I'm silent. I'm not informing anything. That meaning I'm not happy with the terms and conditions discussed. Now, legal effect of anticipatory breach of contract. That is important. One is promisee is excused from promising the contract, from performing the contract. The promisee, in the case of publisher, whatever royalty he has agreed, he need not give that. Second is promisee can consider the contract as cancelled. The publisher can consider the contract as cancelled. Then promisee can sue the promiser for breach of contract. The publisher can sue me for not fulfilling my words because he might have waited for publishing the book. So these are the legal effects of actual breach of contract, and anticipatory breach of contract is different. One is cancelling the contract. One is promisee is excused from performing the contract, and they can, both the cases they can sue for. One is sue for damages, one is sue for breach of contract. So this is what I wanted to explain in this module. Happy learning. Thank you.